Okay, so we're not going to stay in slideshow for very long, but I'm going to take you into a document in a moment so that I can show you how I work through a problem question in my mind whenever it comes to express co-ownership, and that can give you a structure that you then might want to apply for preparing for a seminar next week, and also then in consideration of where you'd approach it as an assessment question. So we'll work through that, and then I will explore and explain the Trusts of Land and Appointment of Trustees Act 1996, because a thorough answer to a question in this area would also address it as a dispute with the correct statutory provisions as to how that would be supported. So we can look at that as well. And maybe some of the questions you've asked me before about how our beneficiary under a trust so far would have been handled will be answered by some of the provisions that we look at when we're thinking about the Trust of Land and Appointment of Trustees Act 1996. So with that in mind, what I like to do is, as I say, show you how I work out. You know that you should be used to how I work out now in registered land, that kind of FESAP, how I shorthand the four boxes and give myself a skeleton framework to make sure I get the basics out of my mind. Very helpful for if you're doing exams, but obviously we don't have an exam situation to worry about, but it can be a very good revision tool just so that you're not spending long time kind of scribing stuff out. If you've got a format for yourself to shorthand things down, and also visually it can help to make something click. So I'll show you a format for how you can work through an express co-ownership problem, almost like a maths equation, as to people coming and going inside the brackets, coming outside the brackets, etc. So we will do that together first. Then in rounding out, and you'll see it when we do the question in seminar next week, and also to prepare you for assessment, whenever you're rounding out a question in this area, you're best to use the TOLATA if you can. So the Trust of Land and Appointment of Trustees Act 1996 being the piece of legislation that would pertain to how this ends up in court and what the court will look at when they're protecting any of these parties. We'll look at how the trustee should behave and what their duties are under TOLATA, so giving us a clear, identifiable way of viewing the trustee's behaviours. We're looking at that and focusing on it within express co-ownership. If you wanted to cast your mind's eye back to overreaching, or how somebody should have treated their beneficiary whenever they were dealing with the overreaching scenario, you could bear that in mind also. It's not something I expect to see in a registered land problem question, but it might make some sense of behaviours that we've already looked at when a party's trying to sell a piece of land over the other one. We'll look at then how the beneficiary can respond to that. So what are their rights under TOLATA? As I say, we're not looking at overreaching as a mechanism here. We've done that. What we're looking at is what the beneficiary will be entitled to under TOLATA, and what TOLATA might then deem to be a breach of trust if these things haven't been complied with. Also then considering the court's intervention. So this is a dispute resolution mechanism. How does it end up in court? And are there exceptions to when TOLATA is the right provision to use? So we will look at all of that together. Okay, so I've given you an example scenario here that has very, very basic kind of minutiae of what might occur within a problem question. It's very simplistic. It's just a starting off point. In 2009, Whiteacre was conveyed to A, B, C and D as joint tenants in law, so of the legal title. The following year, A, having finished university, decided to live abroad, left a letter at Whiteacre addressed to B, C and D that he would like to hold his share independently of their interest. the next thing that happens. So usually in an express co-ownership you have various timelines and parties dropping in and out through the years. In 2010, B and C go to the pub and discuss the idea that the co-ownership situation was not ideal, as D was a bit of a loose cannon, and they agreed between them to separate their interests. Last year, D became bankrupt, so it definitely was a loose cannon, and the bank are now seeking an interest in Whiteacre. So that's a very basic and simplistic problem that still articulates a few of the issues that you would have within a problem question in this area. So what I'd like to do for a moment is take us to a Word document and show you a skeleton framework as to how you could set that stuff out in your mind. Okay, so we have this beginning point, this 2009 moment where Whiteacre is transferred across to 4 parties in the eyes of the law. So we know we have a legal title. I'm going to start out with my legal title. I'm going to recognize that there are 4 parties, A, B, C and D. We would so far have recognized those parties as the fee simple, absolute and possession holders under section 11A of the Law of Property Act 1925. But now what we can do is we can recognise that because we have 4 parties as owners, or as the fee simple, absolute and possession holders, we have to do more with that because we're dealing with express co-ownership. So yes, you would then put your plus the deed and plus the registered land element there, but we're not doing that at this present moment because I'm trying to get you to focus on what it is I'm doing with you as an express co-ownership situation. So we have 4 co-owners. We're told that they are joint tenants in the legal title, and that's all they can be. Where we see joint tenants, my way of dealing with it is to put them in brackets. They are joint tenants on the legal title because that's all they can be. You could put the statutory authority in there for that if you wanted to, if you're working it through as a problem question. But as a skeleton framework, we now know that that's what they have to be. That's how they appear. So where we have more than one person, on the legal title, we are going to have an automatic trust created. That means that we end up with a wibbly line below the legal title, and not only will we be dealing with this in the eyes of the law, but we are going to be dealing with it in the eyes of equity too, which means that we have now got an equitable title. As an equitable title, we would have A, B, C and D also down as beneficiaries. So we have A, B, C and D up here as trustees, and we have A, B, C and D appearing down here as beneficiaries. Okay, so that's the simplistic way of looking at what is happening here. What's happening here is that we have got more than one party on a legal title, which is going to create a trust. They have to appear in the brackets as joint tenants because it's not possible to have a quarter of a legal title. You have to have a whole. So what we have to do is we have to join them together, put them in brackets and keep the legal title whole with the 4 of them inside. That means that their legal title is indivisible. You can't carve it up, you can't make shares of it. All of that would happen down here in equity. In equity then, we could look at it and consider whether they are joint tenants or tenants in common in equity. Joint tenants being in the brackets and tenants in common being severable and separate for their own specific share. the way of dealing with that would be to consider whether there were words of severance used at the outset, and that you had case law for that in the previous lecture. You would also consider the four unities as to whether the four unities are present of possession, interest, time, and title. And you would see if there were any equitable presumptions, such as an unequal split or mixed purposes business use, sorry. So these are the three things that you could do to consider whether, in the eyes of equity, they hold as joint tenants or tenants in common. Do they want to be a collective within brackets, or do they want to be separate and severable and independent of each other? Here, we haven't been given enough information. In a problem question, you possibly would be. So you'd be looking to see if there are any words used in the transfer, if it's a will, or in the sale that would sever them from the outset. You'd be looking that they took the title at the same time in the same document and it existed as the same duration. And you could consider whether there were any equitable presumptions if you were told they didn't pay in equal shares. So in the absence of all that, and because I know the answer, I'm going to put them in as joint tenants. But if I was writing this as a piece of coursework, I would have to have produced all of that analysis. So they are joint tenants. They are staying in brackets in the eyes of equity as well as in the eyes of the law. They are a unit and they operate as a collective. So if one dies, the brackets shrink and they go from 4 to 3. They don't end up with any percentage. Okay, so the next thing that then happens is the following year, A, having finished uni, decided to live abroad and left a letter at Whiteacre addressed to B, C and D that he would like to hold his share independently. So with it being something like a maths problem, what I'm going to do is I'm going to drop it down there and carry on working with it below. I'm going to take that stuff away, but that's what you would always do at the start of any problem question. Articulate who your owners are with the right document, etc., etc. Okay, so now we have a situation where it seems that A is trying to sever. So has A successfully severed? You would look at the ability to sever under section 36(2) and the fact that we would look for that to be in writing. How it should be delivered under section 196 of the LPA. You've got some cases like Re 88 Berkeley and Kinch and Bullard, etc., as to whether what he's done is enough in leaving a letter at the house. And if you can't remember, it is. So the fact that he's left that letter would be sufficient to sever himself from the equitable title. Okay, A's moment of severance then, it has been achieved in writing, it's been left at the place of abode. I'd put the cases in, I would do that analysis. What that effectively then does is it takes him outside the brackets as a tenant in common independently of the others for his share of 25%, because a severance at a later stage under Goodman and Gallant would effectively make it equal in that moment of severance. So no, everybody hasn't severed, only A has severed his interest from the others. A takes himself outside the brackets for 25% because it becomes an equal share in that moment of severance under Goodman and Gallant, and the rest stay as joint tenants. So that's physically what would happen to everybody's percentage hold in that key moment. Okay, so again, I'm going to get rid of trustees and beneficiaries as well because we know that now. Another thing happens then in 2010. In 2010, we have another situation where something else happens. So in 2010, B and C go to the pub, discuss the idea that co-ownership is not ideal, as D was a bit of a loose cannon, and agreed between them to separate their interests. Okay, so here we have these two parties having a conversation with each other as to whether they should sever from D, who's effectively the only other person left in the brackets. So is this moment where B and C are severing? Now, there's no writing under section 36.2. It hasn't been left at the house or recorded delivery under section 196. So we would think about whether this is like Williams and Hensman, either some sort of mutual agreement or course of dealings. The problem with that being all three parties that were in the brackets would have to be in mutual agreement, and here we only have 2 out of 3. So at this moment there is no severance because it's not mutual. Only 2 out of 3 are having this chat, and there doesn't seem to be any evidence that they've communicated this effectively to D. So nothing changes. Severance hasn't happened, and it stays exactly the same as it was before. The next thing that happens is that D becomes bankrupt last year. We know that as above, there wasn't any change. So B's bankruptcy will operate as a way of severing him. So B's bankruptcy, I have ended up with a different font, but I have. B's bankruptcy is an act of severance. It's not him severing, he has been severed. And this is Williams and Hensman. It's seen to be him operating on his own share, even though it's not him operating on his own share. It's being operated on his behalf. So what will happen in this case is that B will be taken out of the brackets because of his bankruptcy. And again, at that moment of severance, would have their percentage share that would be equal with whoever's in the brackets. No one else has died, nothing else has happened. You get a lot of death and awful happenings in problem questions with express co-ownership, but I've kept this one reasonably basic. Here we have B becoming bankrupt for his share, which would still be 25%. So the 25% goes to what's referred to as B's trustee in bankruptcy, who effectively passes his share across, and B's trustee in bankruptcy becomes a tenant in common for 25%. Okay, so that's what the equitable title would look like. No one has died. All 4 of them are up on the legal title still. As joint tenants, it's not possible to sever that ever. Down in equity, we have C and D still in the brackets. It's D's bankruptcy, sorry. I have completely miswrote that one. Okay, so it's D's bankruptcy. Right, so we've got B and C still in the brackets together. If B were to die, C would get half a house because they are still a union, they're a collective. They haven't severed even since this bizarre conversation up here. that wouldn't count retrospectively. There would have to be a new conversation now around them severing mutually. You could raise it, but it's debatable. A remains a tenant in common for their own independent share of 25%, and B's trustee in bankruptcy is a tenant in common for their 25%. Yeah. D's, sorry. So that would be how to mathematically work through a problem question like that from the start. You would split your legal title and equitable title clearly in your mind, knowing that you're still doing that good stuff that we've already known how to do. You would group them together collectively as well as joint tenants in the equitable title with some of this analysis. And then what you're doing is you're looking at subsequent moments as to whether they have severed their interest successfully of each other or not. A did sever because he met the statutory mechanisms to sever. B and C did not sever because it wasn't mutual with all three parties that remained in the brackets. And D's bankruptcy did sever him, taking him outside the brackets, giving his share to the person who holds all of his estate, and they hold it for 25%. What we're now about to do is look at the Trust of Land and Appointment of Trustees Act as a dispute mechanism, because what could happen is that any of these parties could now approach the court and ask for the property to be sold, including this party here. The trustee in bankruptcy could very well ask for the property to be sold. And that mechanism would take place under the Trust of Land and Appointment of Trustees Act. Similarly, A could, B or C could, because they have that right as a beneficiary to approach the court. So that's what we're now about to look at together. Right. So, the Trusts of Land and Appointment of Trustees Act is a very long title, but effectively it is quite simplistic in that it's not solely for us something we are going to investigate in terms of how to appoint a trustee. We're going to look at what it does to trusts of land as regards the trustees' duties, how they have to behave, and what beneficial rights there are under the trust according to it. Mostly, however, and for the purpose of doing any problem question in this area, you'll need to understand that this is the provision that allows it to go to court. This is what the parties rely on to take it to court to say that they want to release their percentage of the house. So the Trust of Land and Appointment of Trustees Act was constructed in 1996 in order to simplify any dealings that there were with trusts and to give a voice to beneficiaries ideally. It clarifies the situation when a trust arises, and by referring it to a trust of land, it's very helpful in removing that language usage of the trust for sale. However, it doesn't remove overreaching, so overreaching still is allowed to happen as a mechanism. For us, it's helpful in clarifying what it is that a trustee has to do in order to comply with their duties, otherwise they could be seen to be in breach, and it also clarifies what a beneficiary should expect of or ask of a trustee, again understanding that if that's not provided for, there will be a breach. And what it does is it makes any of the situations we've previously looked at as regards a beneficial interest under a trust through a resulting or a constructive, any form of implied trust, and what we're dealing with now, a trust of land, and not a trust for sale anymore. So we get the provision of, I'm not just going to read hopefully bits of statute out at you, but it is useful for us to know, and if you've got a statute book to hand, it's something that you should recognise and articulate as being important, and something that would help support a piece of coursework in this area, to know that you're dealing with a trust of land, section 1A of TOLATA 1996. So quite descriptive from the get-go, telling us what a trust of land is. What it does as well is, if you remember what we did a moment ago, we put those people up at the top in brackets and we recognise them as the fee simple absolute possession holders, and that's also recognised within section 6.1 of TOLATA 1996, that in conducting themselves as trustees, the trustees of any land have the ability to behave, or the powers of, an absolute owner. So they are behaving like the fee simple absolute possession holder. They are the one who can carve out other estates and interests in land, raise equity on it, lease it out, sell it, let people live there, ask people to leave. All of those things that a true owner would do is how a trustee can behave within the powers given to them under section 6.1 of TOLATA. So, yep, they can sell it, they can let it, they can mortgage it. The trustee could buy other land as an investment, or they can have the land for a beneficiary to live on, or for any other reason that they choose. So it's for the trustee to think about what's in the best interests of the beneficiary and behave in that way. Remembering, whenever we looked at mortgages, that that's not how a bank had to behave, but this is how a trustee has to behave. They think about what would be in the best interests of that beneficiary and they behave accordingly. They can also then transfer the land, so they can allow the beneficiary to become the fee simple absolute and possession holder of the land if they come of age. So that happens where a trustee might not want to be the trustee anymore and don't need to be a trustee anymore, because the trust land was for the protection of a minor and that minor has come of age. However, the trustee has to have regards to the rights of their beneficiaries, and we'll see in the power of consultation and consent, or the duties to consult and achieve consent, that that means they have to allow their beneficiaries to be heard and then behave in accordance with those wishes. And there should be no profit. So that's not what a trustee is there to do. It's not there to profit from the position of being a trustee, but is there to run the trust and to protect the beneficiaries. So the duties of a trustee, how the trustee should behave as regards their beneficiaries. They should consult their beneficiaries, the ones that are of full age, and as far as is consistent with the general interests of the trust, give effect to the wishes of those beneficiaries. So what this means is, if the trustee is thinking about doing something with the land, they would consult any beneficiaries that are over 18 and who are interested, who have beneficial interest in living there. They have to think about what was the purpose of the trust. So there, where it says within the general interest of the trust, they're thinking about the creation of the trust, who created it, who made it happen, what did they have in mind whenever they created it. Was it meant to be a matrimonial home? Was it meant to be a business property? Like, what was behind it from the outset? So we've got to bear in mind the intentions of the original testator, or the original person making the trust, and give effect to the wishes of the beneficiaries once they have consulted with them. The so far as practicable means that they have to do what they can to get hold of somebody to ask them that question. So that will depend upon where the beneficiary is and how contactable they've made themselves. The trustee doesn't have to trace them down to the ends of the earth if the beneficiary hasn't made themselves available or accessible. So there is some limitation there as to, so far as practicable, meaning it has to be possible for the trustee to be able to get hold of them in order to ask them that question. If they can't, then they'll have to behave in light of what they think is best. So as regards consultation, as I said, the beneficiary must have full age, be over 18 and be capable of possessing the land itself, so have an interest in some form of residence there. It has to be realistic, so that so far as practicable thing means that the beneficiary has to be able to be contacted. Then in thinking about what the beneficiary's response would be to that proposal, the trustee would honour the wishes of the majority of the beneficiaries. If there are 2 out of 3, 3 out of 4, the trustee honours the wishes of the majority. However, overreaching still exists. Oh, 2 R's in overreaching, sorry. Overreaching still exists as a mechanism that is there to take beneficiaries out. So you could ask, but as we've seen with any of those cases so far, we've got one trustee, and usually that trustee is then also a beneficiary because they live there, and we will have another beneficiary who's their other half. So if you're going to ask them and they say no, it's hard to get a majority out of 2, so overreaching is still possible. And in thinking about that, what could happen is that the overreaching or the mechanism or the transaction could go through, and it's then for the beneficiary to claim there's been some sort of breach of trust and take it to court, which will be too late by then because the property will be gone and the new purchaser won't be bound by them if they've been overreached. So it's important to know that those mechanisms still exist that we've already looked at, and that this is an interesting point that is valid, but it doesn't negate overreaching. All that should happen really is a canny beneficiary would be best to put some very clearly worded restriction in to avoid overreaching, taking them out and the money going to the wrong place. So consultation's been dealt with, and we look at occupation. I haven't got to consent yet. Occupation, the ability for the beneficiary to live there. A beneficiary is allowed to live there under Section 12. So if they're entitled to an interest in possession, they can occupy the land at any time. So that gives them the ability to live there if that's what they wish. However, that means that they have to have the right to occupy enshrined in some form of possession of theirs, so they have to be entitled to possess the land. It has to be in the mind of the trust when it was originally created, that's how it might be that's what might be done with it, that's what the property could be used for. The land must be available, so the land must be free to allow somebody to live there. If there's a tenant, for example, it's not right to kick the tenant out, or if the property is full in some other way with other people, it may not be possible. So yeah, Section 13 would mean that the trustee has choice about this. The trustee can look at a range of beneficiaries and decide that one would live there and one wouldn't. Also would think about whether it's in the best interests of the trust that that person lives there. So say, for example, the trust property is massive and the beneficiary wants to live there, but it's a 10-bedroom mansion. The trustee would think, well, that's not in their best interests. Actually, it would be better for me to buy them a little cottage or a little flat somewhere and make the money from the 9 or 10-bedroomed mansion. That would benefit them in more regard than them rattling around in the place on their own. So the trustee retains some authorship around that and some control. Section 13 gives them the ability to weigh up options when thinking about whether a beneficiary should live there or not. So Section 14 would be application to court. So thinking about going to court about any of this would be down to a beneficiary feeling wronged in some way, or potentially a trustee just wanting clarification, or a bank who have become a trustee in bankruptcy for a share being able to approach the court themselves. So Section 14 allows these people to come to court and apply for some consideration of their interest or the behaviours of the trustee or their rights to be established in some way. Can they live there? So any person who's a trustee of land or has an interest in the property subject to a trust of land, so that means a beneficiary or any other party who ends up with a share, i.e. a trustee in bankruptcy, may make an application to the court for an order. On application, the court may make such an order relating to the exercise by the trustees of any of their functions, or declaring the nature or extent of a person's interest in property subject to the trust as the court thinks fit. So yeah, the court will stipulate how a trustee should be behaving, what a beneficial right is in the property, whether that's a percentage, whether that's living there, whether that's it being sold, whatever it might be. Any of these parties can go to court and ask for clarification on these matters under Section 14 of TOLATA. So the trustee or the beneficiary or another interested party, such as a creditor of theirs, can make an application to the court. It refers to, bizarrely, even though it's the Trust of Land and Appointment of Trustees Act, it refers to the duties of the trustee or the benefits of the beneficiary or their rights, and not actually how a trustee was appointed or whether to appoint a different trustee. So this dispute mechanism is about clarifying the areas we've looked at about consent, consultation, whether they can live there, how big their share is, any of that stuff. The court might say that they don't need to consult or obtain consent. The court may determine the nature or extent of the beneficial interests, so that can include occupation, that can include their share. So yeah, basically what happens is that any of these parties approach the court for some clarification or for some guidance or in a dispute in relation to it. Then what the court will do is they will look at the range of matters in considering how to respond to this request. They will look at who created the trust, why the property was held. So what was the intention behind taking that property? Was it meant to be used as a commercial entity? Was it meant to be used as a family home? They'll think about the welfare of any child who occupies or be expected to occupy the land. And they will also, and most importantly and pressingly for where we're about to head, they will also consider the interests of any creditor of any beneficiary, and that means the bank, especially if somebody's bankrupt. So all of this stuff is what the court weigh up when they're thinking about whether to effectively allow somebody to live there or give them a percentage or allow the property to be sold, and that beneficiary can include a bank. So it's quite, it really flicks the balance at times. Exceptions to when the courts will consider TOLATA would be for bankruptcy. So where there's a bankruptcy, instead of Section 14 and Section 15, we would have Section 335A of the Insolvency Act 1986. So this would be the relevant provision as to how a trustee in bankruptcy would approach the court. So this is the ability for the trustee in bankruptcy to apply for the sale of land. So they want to push for the sale in order to get their percentage and satisfy the debt. The court will have such matters as it thinks. So the list changes. Instead of the list we have in Section 15, we end up with a different list. So they'll think about the interests of the creditors. They'll think about the land being a dwelling house and anyone else who lives there. They will consider whether there's been a contribution from a spouse or a former spouse. They will consider their financial needs and the needs of any children. So there's a range of things that are considered under Section 335A that are slightly different to those that are listed in Section 15 of TOLATA. In conflicts, however, historically, where we've seen a conflict between the bank and someone else who lives there, unfortunately, in re Turner and re Citra, we haven't seen the courts being particularly kind in those scenarios, and we have seen that in certain scenarios like that, the courts have been quite willing to find in favour of the bank instead of the wife or husband of the party who are bankrupt. So a family home can and will be sold above their heads where there's bankruptcy, irrespective of their interest in the land too. So again, we can see this preferential treatment towards banks being given throughout. Other area of point of interest would be family law. So in family law, we'd use different legislation and provisions. So again, instead of section 14 and section 15, the section 24 of the Matrimonial Causes Act 1973 would come into effect where the parties are married. And section 25 as well. So the court has an unlimited discretion under section 24 to reallocate property between the parties in a divorce, and the adjustment includes either transferring the property to the other partner or ordering the sale of the property. And then again, so that would be the ability for the court to behave that way. And section 25 then would mirror the section 15 of Talata in giving guidance to the court as to how and whether to exercise that power. It looks at their incomes, the financial needs and obligations, family standard of living before the breakdown of the marriage, how long the marriage went on for, any disabilities or impairments, contributions to the family or caring for children, the conduct of the parties, any pensions and other rights. Okay, and we can see that in effect in White and White, where it didn't really matter how rich the parties were, that even in situations where there are large assets, that an absence of financial means and an absence of financial need doesn't mean that you should depart from a generosity of approach. And the courts can make settlements that reflect that. Not just their financial needs and requirements. So yeah, giving that ability, that power through a normal divorce, as you might be aware of in family law, to decide on a fair allocation of the resources. That's mirrored in section 65 and 66 of the Civil Partners Act, which would pertain to the same sorts of disputes, but then where we're dealing with civil partners instead of matrimony. The only requirements differing there that thought about contribution of a substantial nature by one party or another, as well as that consideration of any works done on the property. So that all being dealt with within those subdivisions and provisions there, that you see different clauses pertaining to whether one party has significantly contributed to some form of redevelopment or works performed on the property itself. That's something that would require evidence for the court. Excellent. So I hope that the working examples things has cleared up some issues that might have entered your brain in the last session, and you can see how you would work through a problem question in this area. I would also advise that you round out at the end by thinking about Talata and its ability to act as a dispute resolution mechanism. So any of these parties are approaching the court to either determine how a trustee has behaved or consider whether rights have been broken or an interest should be declared, bearing in mind that the rules are mirrored but are slightly different where we're dealing with either a bankruptcy or a marital breakdown. Thank you very much.